From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court gives a big win to the Seventh Amendment, ruling against in-house judges at the Securities and Exchange Commission and in favor of the right to a jury trial. Plus, what to expect as Joe Biden and Donald Trump get set to take the stage tonight for the first presidential debate of 2024. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. It's another big day at the Supreme Court. The justices releasing 4 more opinions, including one that could be quite consequential for the administrative state. That is SEC versus Jarkesy. George Jarkesy is a hedge fund founder who was charged by the SEC with fraud in a case that was heard by an in-house administrative law judge, or an ALJ, who ordered him to pay a $300,000 penalty and barred him from the industry. But what about the Seventh Amendment? It is perhaps an underappreciated amendment, but definitely in the top 10. And here's a piece of what it says. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. So, Alicia, with that groundwork, can you give us a sense of what the 6-3 majority in this case did?
So they held that because the SEC's claim against Mr. Jarkesy was a securities fraud claim, which is very similar to a common law claim of fraud. For instance, that if you sue me for fraud, that's common law. You're suing under either federal or state courts. And these were kinds of claims that were actually adjudicated in court at the time of the founding. And the 6-3 majority held that these kinds of claims must be tried in federal courts. So the SEC cannot go through its own administrative process. And just to describe how this usually works is that the SEC will bring a charge against an individual, and increasingly it doesn't have to be against anyone that is regulated by the SEC, like a broker. It could actually be any individual in America claiming that you violated a securities law and committed fraud, and they will put this through an administrative process. And what this is an administrative law judge, which isn't an actual federal judge. They have not been appointed by the president or confirmed. They are not an Article 3 judge. And they will hear the charge, and there's a truncated discovery process. It's pretty well stacked against the defendant. And after a year or two, they will typically, almost 100% of the time, rule against the defendant and rule in favor of the agency. And in that case, then you can appeal to the full SEC, the commissioners, and there are 5 commissioners. And what you know, they will almost always rubber stamp the administrative law judge because they agreed to bring this claim. So why wouldn't they? And so this is essentially what happened here, is that the SEC rubber stamped the ALJ's ruling and ordered him to pay a $300,000 penalty and went even further and barred him from the securities industry. Now, Mr. Jarkesy, who was a hedge founder, appealed in federal court at the Fifth Circuit and argued that these tribunals violated his Seventh Amendment right to trial by jury. And you just read what Seventh Amendment says. And he made some other arguments that the ALJs weren't properly appointed because they had enjoy multiple layers of for-cause tenure protections. But the Supreme Court here actually just focused in on one particular claim, that's the Seventh Amendment right to trial by jury. And here the Chief John Roberts, ruled and held that, yes, this is a common law claim, and therefore the SEC cannot basically end run the Seventh Amendment and stack the cards in its favor by going through its in-house judge to penalize Mr. Jarkesy, and that any kind of civil penalties that it seeks to levy against defendants will actually have to go through federal court. So the SEC can no longer play judge, jury, and prosecutor in cases.
And part of the dispute between the majority written by the Chief Justice and the dissent by Justice Sonia Sotomayor is this term called public rights, because there are examples the dissent is pointing to where Congress uses its sovereign power to create some kind of setup that does involve agency adjudication. And one of the examples that Justice Sotomayor points to is OSHA. In 1970, she says Congress enacted the Occupational Safety and Health Act, and that allows a commission to impose civil penalties on employers maintaining unsafe working conditions. And then she says that this court upheld OSHA's statutory scheme, relying on a long series of precedents. And Kim, part of what is interesting here is the Chief Justice, in his opinion, acknowledges that and says that these distinctions are a little bit messy. But if I'm understanding him correctly, his basic thrust is that fraud is a classic kind of thing that you would end up in front of a jury in a court for committing, and that Congress cannot take that out of court by a statute, even if it can create new sorts of schemes like OSHA.
Absolutely correct. And one thing I would add to that very good description that Alicia had about the problems with this and common law is that the majority also went out of its way to note that it's not just that money damages are an absolutely classic common law question, but that what also, as part of this case, made it necessary and others to be entitled to a jury trial is that it was retributive. It was a punishment. This was not just a case of the SEC attempting to claw back money to make victims whole, to remedy a wrong. It was serving as a punishment to the defendant. And as such, those cases absolutely must have the right to a trial by jury. But, when you look at this public rights exception, the bottom line is this, just to step back and look at this issue a little bit. The Constitution prohibits Congress from withdrawing from the judiciary any matter which is related to common law. And that's where you get the word public rights exception. And what we have here are a series of cases that the majority does note where in very discrete circumstances, they have given Congress an exception to that prohibition, but they are in very defined areas. They have tended to be. So the collection of revenue, customs enforcement, immigration, etc. And Gorsuch had this really wonderful, witty, and funny line in his concurrence. And he said, despite its misleading name, the exception does not apply to all matters brought by the government against an individual to remedy public harms. And the Chief Justice got in this a little bit too, noting this is an exception and has to be evaluated, these cases, with care. Otherwise, the exceptions will swallow the rule. And you could end up in a situation where any time government passes a law in which it says it is entitled to civil penalties, jury trials just disappear off the face of the earth. And that is actually quite a scary situation. So it's unclear where some of these other statutes like OSHA now and other public rights exceptions stand given this new decision. The majority did try to make some distinctions here, but this could come back and go back up to the court again. But broadly, this was a very good and clear decision that I think not only validates one of the most important rights we have in this country, which is a right to a trial by your peers, but also may deal with some questions of congressional powers and how far it gets to go.
Hang tight. We'll be right back in a moment. Welcome back. Given this distinction between public rights and what was at issue in this SEC case, how much do you expect this precedent, Alicia, to affect other elements of the administrative state, maybe other agencies? And one thing I would also point out is the majority opinion here says that an appeals court found other defects in the SEC's process here. So as one example, it says that the Fifth Circuit determined Congress had violated the non-delegation doctrine by authorizing the SEC without adequate guidance to choose whether to litigate this action in an Article III court or to adjudicate this matter itself. So the majority did not reach that legal question because this issue of the jury trial and the Seventh Amendment was enough to settle the case. But there are some other lingering legal issues here that you could see in future cases. For example, whether the SEC is allowed, without any guidance from Congress, to just determine, do we want to try this as a case in court or do we want to try this as a case in our own administrative tribunals?
Right. They didn't have to reach that because they just ruled that this 2010 Dodd-Frank Act provision was unconstitutional. So they didn't have to get to that. And the other argument that was made at the Fifth Circuit and the Fifth Circuit it gets substantiated was that the ALJs, the administrative law judges, violated the separation of powers in terms of their double removal protections. And that claim is being brought in other agencies with similar structured administrative processes in which ALJs decide cases. And for instance, the NLRB, interestingly enough, Elon Musk has brought a complaint on behalf of SpaceX against NLRB in the Fifth Circuit, arguing that its administrative processes, including the ALJs and the lack of trial by jury, violates the Constitution and cites the Jarkesy precedent. In fact, he submitted an amicus brief in this case. So the decision today, or the decision on Thursday, has pretty far-reaching consequences, and much more so than maybe some of the other court's landmark opinions in administrative cases, because all of a sudden Gary Gensler is going to have to now go before an Article 3 judge and convince him that certain actions violate securities laws. This is really going to rein in regulators like Gary Gensler, who prefer to go before their in-house judges because they are almost always win. Here you will actually have to go before a judge and potentially a jury and argue cases. And, in those cases, they often don't win. They're not as deferential to the administrator's own view of their powers. The court still hasn't decided a couple of other cases that are challenging to the Chevron doctrine, in which judges are required to give deference to an administrative agency's interpretation of the law when it is vague and ambiguous. But if there is some kind of reining in or actually overruling this Chevron precedent, this combined with the Jarkesy case is going to substantially limit the powers of the administrative state.
Kim, any last thoughts from you on the consequences of this ruling in a government and an administrative state that now touches a lot of aspects of American life far beyond securities law?
I just put this into the bigger continuum of the Supreme Court cases when it comes to the administrative state. And I would remind people, I've told this story before, Donald Trump's first general counsel, Don McGahn, was himself a commissioner at one of the agencies and was appalled by the degree to which the bureaucracy ran the asylum instead of those who had been named and confirmed. And I know very much that he advised Donald Trump on his picks for the Supreme Court with an eye to getting judges that were both steeped in administrative law and skeptical of the powers of the bureaucratic state. And we're seeing that in a long run of opinions now, which are very heartening, I think, to those of us who'd like to see that power reined in. But, from the West Virginia to EPA decision, the Waters of the United States decision, we've got this decision today, another one today that slapped back the EPA in terms of its powers to ride roughshod over states into the Clean Air Act. And then we're likely, to get some opinions maybe tomorrow or Monday from the court dealing with Chevron deference, or whether or not judges must simply defer always to the experts at the bureaucratic state. I think this is a pretty impressive track record so far by Barrett, Kavanaugh, Gorsuch, who have written a lot of these decisions. This one happened to have been done by the chief, but the Gorsuch concurrence in it is very good and brings up some points, very much shows judges that are paying more attention and want people to stay in their lane.